Our presenters today are going to explain a little bit more in detail how some of those aspects of HOA law need to be dealt with and affect us. And one of those presenters is my boss, Bruce Jenkins. And I'm going to tell you a little bit about Bruce and then let him take over. Bruce has represented community associations since 1991. Now, I mentioned that I'm getting old. Bruce, I don't think that I was in high school yet in 1991. And so I'll tease you a little bit about that, but I'll also point out that means, think about how much experience Bruce has in the realm of HOA law. In fact, I would be so bold as to say that Bruce is the sort of father of HOA law in Utah. Nobody knows more about HOAs than he does. He has been involved in creating the statutes that we use. His legal practice focuses on homeowner association law, real estate law, construction defect, and business and civil litigation. In addition to being a member of state and local bar organizations, Bruce is a member of the Community Association Institute, the Southern subchapter in Southern Utah. He was the legislative chair for the Utah CAI, which is kind of a trade organization for HOAs, from 2017 and 2018. And then he was the first vice chair of the Utah Community Association Bar Section. And I want to add some things that I have seen personally. Bruce is not just the most knowledgeable person in Utah about HOAs, but he is a fantastic person with a real keen intellect that allows him to see quickly to the heart of complicated issues involving HOAs, and then come up with really good solutions and then explaining those in simple ways. And I have had just a tremendous love to work for Bruce, frankly. I will say too about Bruce that he's been an expert witness and a presenter on community association matters at national and local conventions. And then for 2 years, Bruce was also in-house counsel for a St. George developer. He regularly trains managers and association board members, and he's published several articles on homeowner association matters. And I know too that Bruce loves the outdoors. We'll personalize him a little bit. And he's just a fantastic person, and pay attention because you'll learn a lot from him. So with that, Bruce, take it away.
Thanks, Jeremy. You probably said more nice things about me than I clearly ever deserve, although I have been doing HOA law for a long time. And I find it intriguing, stimulating. I mean, for any of you that get involved, it is not a simple practice. Anywhere from multi-million-dollar construction defect cases to a dog pooping in the common area, contract construction, contract interpretation, statutory drafting, statutory interpretation, the whole realm of that. I'm going to talk a bit about the creation of the covenants and how that's done. But to sort of tee that off, I'm going to ask a question. I know I'm not going to get responses, but I'm going to ask a question and then give you an answer. It's a question that I would have gotten wrong early in my career. And that question is, are all things in CC&Rs covenants and equitable servitudes that run with the land? They're either recorded, they say that they are covenants of covenants and equitable servitudes that run with the land. But the answer to that question is no. Courts have determined that not all things inside of those CC&Rs are covenants or equitable servitudes. They are some of those things, particularly the declarant special rights reserved to the declarant to annex an additional property, to appoint the board. Those sorts of things are considered personal property rights, not even real property rights, and are assignable, but are not simply assignable by the conveyance of the land and the transfer with the covenants. So just to, sort of interesting thing as we start talking about the covenants. I think everyone's familiar with the express covenants, those that are signed by the developer. The developer declares that these are the covenants that will govern the land, hence the reference in CC&Rs to declarant. The declarant is the person who owned the property and declares this is how this property is going to proceed under this scheme of development. I'm not going to talk a lot about that one, probably not even any more about that one, because that we are all familiar with. I'm going to tackle some of the more difficult ones, including creation of covenants and associations by the government, covenants by estoppel or implication, and a recent question in Utah whether ratification of covenants not properly adopted or properly executed, or even maybe not properly recorded, can by ratification become covenants binding the land and running with the land. So with governments, it doesn't happen often, but there's been a few situations in the Midwest and one in the Northeast where associations were in such a condition of blight that the local municipalities stepped in, created a special service district, created a homeowners association, and made everyone in that district be part of the homeowners association so that they could levy special assessments through the association to, once the through the special district process, once the property was taken out of a condition of blight, it could be maintained by the association through those level of assessments. Again, it doesn't often happen, never seen it in Utah, but in an odd instance where you are looking at aging communities, maybe downtown areas where an area is blighted, it's possible even for the government to create those. Even the restatement of property, the third restatement, property dealing with servitudes, talks about creation of associations by the government. Next would be by estoppel. And the restatement, section 2.10 says this about creation of servitudes by estoppel. And again, I don't have the slides, and I apologize for that. I'll tell you briefly why I don't have the slides, and I can provide information afterwards if anyone wants to email me, and I can give you that information. But I was in the hospital most of last week with kidney issues, and so I didn't put together my slides. So I apologize for that, but I can get you that information if anybody wants it, and the information I'm going to talk about today. The restatement in section 2.10 says this: if justice can be avoided only by establishment of a servitude, the owner or occupier of land is estopped to deny the existence of the servitude burdening the land. And I give two examples. One is if the owner of the land permits you to use it, and then you change your position based upon those standards, then you cannot be, that owner of the land is denied and is stopped from allowing you to utilize that land under the conditions that were described to you. The second one is if the owner of the land represents, hey, I believe I'm burdened by your covenants through their statements or actions, then they would be stopped from denying that, where the association or other owner acted in reliance upon that. The closest thing we have in Utah to a case that deals with that is the Danzy versus High Country Estates case, Supreme Court case in Utah in 1999. And they dealt with it in terms of not calling it a servitude by estoppel, but the owner had actual or constructive notice of the CC&Rs. And in that one, the High Country Estates subdivision was created. And there was a land surrounding that subdivision that had not been brought into the subdivision. It was likely, from the facts, the intent of the original developers to, over time, annex that surrounding land into the subdivision. And at one point, there was even a contract between the original developer and the subdivision saying, look, we need access to get to our surrounding property through the association streets. We will be a member of the association. We will pay association assessments. That contract was to be binding on successors and assigns. That developer sold off a portion of that surrounding property to Mr. Danzy. And at some point, the association decided, hey, we have not assessed Mr. Danzy's property assessments previously, but we are going to now. And he brought an action for declaratory judgment saying these covenants don't bind me. I'm not bound by the association's documents. The trial court agreed with the association, but on appeal, the court determined that even that contract that said that the prior developer would be a member of the association with respect to those surrounding lands, Mr. Danzy never signed that contract. There was no evidence that he was an assignee of that contract. And so the court determined that he did not have actual notice. Now, in that case, and I'm going to read it because it's the court got it wrong several times early on until say prior to about after the year 2000, the court would make these sort of incorrect statements. They would say restrictive covenants are not favored in the law and are strictly construed in favor of the free and unrestricted use of property. That's actually not accurate. When I say that's not accurate, the cases cited for that, St. Benedict's Development versus St. Benedict's Hospital, Freeman versus Gee, Paris versus Richards. What the court said in those prior cases is that unclear and ambiguous covenants will be strictly construed in favor of the free use of land. Not that all covenants, not that any express covenant would be strictly construed. In fact, the Utah courts, appellate courts now are construing covenants more liberally to enforce the intent and not so strictly. However, when it comes to an implied covenant, the courts still do, and I think correctly so, apply a standard that restrictive covenants are not favored when you are seeking to apply them by implication or by some sort of estoppel. So in that Danzy case, as to the estoppel argument, the court didn't find that it applied, notwithstanding the 1973 agreement. So the next way that covenants can be established, other than say the express, but the way in equity that covenants can be established is by implication. Once again, the restatement is helpful on that. Section 2.11 of the restatement specifically addresses servitudes by implication. And it says the creation of the servitude may be implied by the circumstances surrounding the conveyance of the land. So you look at all the circumstances. In Utah, the first time that was dealt with respect to real property covenants, I believe was in the St. Benedict's development case. In that case, the hospital was built by a developer. There was this understanding that the developer would build professional and medical buildings adjacent to the hospital. The developer believed that there was an obligation of the hospital to help him fill those buildings with tenants. But prior to those buildings being filled with tenants, the Boyer Company entered into an agreement with the hospital to build another set of office and medical buildings. And so there was a suit claiming, among other things, that there was an implied restrictive covenant that required the hospital to contract with the developer to build that other building and or to see that all of the existing buildings were completely occupied before the hospital could contract with somebody else. And once again, this is what the the court said in that case, where expressly stated restrictive covenants are not favored in the law and are strictly construed in favor of the free and unrestricted use of property. You look at those underlying cases, though, and that's not what it says. Those underlying cases that they cite, again, point to if the covenants are unclear or ambiguous, then express covenants are not favored. However, the court goes on to say this: generally, restrictive covenants are upheld only where they are necessary for the protection of the business for the benefit of which the covenant was made, and no greater restraint is imposed than is reasonably necessary to secure such protection. Again, it bugs me, I guess, from a real property law attorney, that quotation came from a covenant not to compete in a case out of Allen versus Rose Park Pharmacy, and they're taking that covenant not to compete language and applying it to covenants. I think the courts in Utah have moved past that now, but that was their basis then. However, they did recognize correctly the following. It says, under certain extreme circumstances, a restrictive covenant may arise by implication from the language of a deed or a lease or from the conduct of the parties. As a general rule, however, implied covenants are not favored in the law. In order for a restrictive covenant to be implied, the support for it must be plain and unmistakable, or it must be necessary as a matter of law. So that got me thinking, what is truly the burden of proof to prove that it must be plain and unmistakable? Some courts in Maryland have determined that if the association, as an example, if the association was trying to apply covenants to surrounding properties, that if the association were to prove that there was a common scheme for development, that they would have met their burden, and the burden then would have shifted to the homeowner to have to prove that the covenants didn't apply, that the association didn't meet the balance of the elements. So there was a shift of the burden. Utah's not clear on it, but when you say plain, in quotes, they quote plain and unmistakable, there's at least in the federal cases with respect to military rights, and I get it, it's not a direct correlation, but I want to read this because I think the burden of proof is not yet clear in Utah what burden you have to show it's plain and unmistakable. But in the federal context, in terms of veterans' rights, it says this: the clear and unmistakable evidence, quote, standard is a more demanding burden of proof than the, quote, clear and convincing, in the quote, evidence. And to satisfy it, the government needed evidence that was undebatable. That comes from a case of Vanderson versus West. It's a 1999 case. But to prove that a covenant by implication applies to some property, I think it's a very high burden, an unmistakable burden that is so plain that it can't, you just can't question it. In many situations, I've seen associations. I've got one in Utah County where an association is surrounded by a golf course. The golf course, to get to the clubhouse, has to drive through the private association streets. The owner of the golf course doesn't pay the association for any of those maintenance costs to drive through the association streets for its patrons to get to the clubhouse. The association believes that the CCNRs apply to that golf course development owner, even though the CCNRs were never recorded against the golf course property. But the implication is, the discussion was, the golf course is a part of the development. You must access the golf course through the development. By implication, CCNRs apply. No one on either side yet in that case has filed suit to have the court determine whether those apply by implication, but I have serious questions of whether they will. Even if they don't, however, I'm not too worried for the association, because there's also case law in Utah says that if there's a common access way utilized by the parties, even if there's no agreement, they must share in their pro rata share of the maintenance. So the golf course, in my mind, will lose no matter what. It's just under what theory they lose under. I have a different case, though, ongoing now, where there's an owner within a gated community. I mean, with guards. I mean, the only way you get into this community is go through the gates and go through the guard station. And he is now, one of the owners is claiming that he's not a member of the association, that there is no association and there are no covenants, because after the first phase, the named declarant wasn't the named developer or named declarant in the subsequent phases that were annexed in. And there's about 17 phases annexed in, I think, something like that. So large community, but the developer would form different entities from time to time to take down other properties and would record the plat maps and the CC&Rs in the name of that entity rather than the name of the original declarant in the original CC&Rs. I believe that case, that on behalf of the association, will win. I think there's a lot of other factors, but I think we will win a covenant by implication in that case, because I think that it will be plain and unmistakable. You don't drive through the guard shack without knowing you gotten into a community where there are only private streets and a number of other things that would support that. So that is by implication. So let me read some of the other parts now in second. Gotta make sure I got the right case. Yeah. So here are the elements that that were addressed in the Danzy case when the court was determining whether the covenants were implied equitable servitudes and could be imposed upon the adjacent landowner, even though they've never been recorded against the adjacent landowner's property. But the association believed that they should have been recorded and then that adjacent land should have been brought into the association. And again, when I read this, I'll tell you, I don't think there's a clear set of elements in Utah to apply covenants by implication to, because this is how the court states it. They say the association relies upon a main case, holding that an implied equitable servitude may be imposed where the evidence establishes: 1, common owner subdivides property into a number of lots for sale; 2, the common owner has a general scheme of development. There may be a plat map or maps, there may be a conceptual plan, there may be prior use, whatever that general scheme is, okay? 3, the vast majority of the subdivided lots contain restrictive covenants. 4, the property against which the application of implied covenant is sought is part of the general scheme of development. And 5, the purchaser of the lot in question has notice, actual constructive, of the restrictions. Now, that was a main case. The court didn't say they adopted that standard. They just said that's the standard the association asked us to apply. And in applying, and they really didn't even get to the point where they applied that standard. What they said a couple paragraphs later is, it's a long-standing and well-accepted requirement that covenants are to be embodied in a written instrument. However, and admittedly, there are certain instances where the covenants can be imposed by implication, such as from the language of a deed or a lease over the conduct of the parties, once again citing the St. Benedict's development case. Those instances, however, are extreme, and as a general rule are not favored in the law. For such a covenant to be impliedly imposed, the support for it must be, again, quote, plain and unmistakable. To me, undisputable, or it must be necessary as a matter of law. So implied covenants, although I utilize those arguments on behalf of associations when there's a property outside or inside the development that is claiming that they are not bound by the covenants, but there's a lot of factors that would support that they should be, that is available. Or at least that doctrine to try to imply covenants is available. Now, the next thing is ratification. And I want to be clear when I'm talking about ratification. If I'm talking about ratification of the CC&Rs, that's one thing. If I'm talking about ratification by the members, the lot owners of an association's ability to levy assessments or do other things, that's completely different. And the reason I say that is because there are some recent cases, again, high country estate cases. I don't know if it's the exact same association, but we can think high country estates in Utah for a lot of case law that we rely upon. But in that case, let me grab it. There's a couple of them. I mean, I thought I had an order. Here we go. There's a series of cases. There's a Swan Creek case, and then there's some high country cases that came out in 2022 and 2023. I think what I'll do to maybe drive this point home, that ratification in Utah has not yet been applied to the covenants as a whole. Rather, the doctrine of ratification has been applied only to an association's authority to act under covenants that have been recorded against the property. So let me go to the citation. In this case, it is the first case is WDIS versus High Country Estates. That's a 2016 Supreme Court decision. And in that case, the Supreme Court determined that CC&Rs, even if improperly executed, even if recorded against the land, and the landowner that didn't sign those covenants, somebody else recorded those covenants against that landowner's land, those covenants nonetheless got recorded. It doesn't mean they're void ab initio. They are simply voidable. If they were void ab initio, the doctrine of ratification would not apply. In terms of contract construction, ratification does not apply to a contract that is void ab initio. Obviously, it can't. The contract's void from its inception. If, however, a contract is merely voidable and not void, it may be subject to ratification. And in the WDIS case, the court clearly stated that there it was the CC&Rs are voidable, but it remains to be determined whether the landowners ratified the covenants at issue in the case. Okay, so that's where we left off in 2016. But then a series of cases, again out of the same association, came up because the association was attempting to collect assessments out of these homeowners, and these homeowners were saying, look, these covenants that recorded against our property, they got recorded, yes, we admit that, but they were not signed by the owner of the land. The developer recorded these covenants against land he didn't yet even own. And the court didn't really care so much about the fact that the covenants were recorded against the land and the landowner didn't sign those covenants, because they narrowed the issue this way. And this is in paragraph 32 of the case of High Country Estates Homeowners Association versus Mountaintop Properties. That was decided to February of this year. And they say in paragraph 32, as an initial matter, we clarify that the question in this case is whether the HOA's members have ratified the association's authority, and authority is italicized, in general, and its authority, once again italicized, to assess the property within the boundaries in particular. Mountaintop's landowners analysis focuses on whether the members have ratified the governing documents, because Mountaintop was saying, hey, all the things you must do to ratify a governing document haven't been done. So the court clarifies and says, and Mountaintop is correct that the HOA was originally established and empowered by those documents. But here, the precise question is whether the HOA had authority to levy annual assessments as contemplated in those allegedly flawed documents. So not in this case, not in the High Country Estates versus Mountaintop Properties, or its companion case, the High Country Estate Owners Association versus Frank. In neither one of those cases did the court pick up the question of whether the CC&Rs could be in whole or even in part ratified by the association members. Rather, the court, and I think did this very intentionally, narrowed the scope of the issue and said, look, all we're dealing with here is this is an HOA trying to collect assessments. And we're saying that the HOA has the authority to collect assessments because that authority has been ratified over the years, because everyone's acted like the HOA is the HOA, and they've been paying assessments over the years, generally speaking. And this particular landowner never objected to the fact that the association was a proper association. Oh, until the association sued to collect assessments, and so the court nonetheless dealt with that ratification of the association's authority to collect under CC&Rs that were recorded, maybe not correctly, but nonetheless they were recorded, and therefore the owners were on notice. And they also clarified that the quote duly recorded doesn't mean, when the court said in their opinions in these high country cases, including the Swan Creek case I'll talk about in a minute, when the court says duly recorded, that doesn't mean that it was properly recorded according to the whatever laws under the Land Use Management Act or municipalities requirements, or even common law. Nothing that says that duly recorded means properly recorded. It just means that, hey, we just said that they were recorded with an agency where land records are recorded, and that's what we mean by duly recorded. So in my mind, the jury is still open on whether covenants in whole or in part can be ratified. But the question is answered, I think, in Utah, that an association can ratify the association's authority to collect assessments by their actions, even if there's questions about whether the covenants were properly recorded. And so the other twist on that is the Swan Creek case. That's a 2006 Supreme Court case. It's Swan Creek versus Warren. And it's not surprising to me that these cases come up because people don't pay assessments. And then when they get sued to pay their assessments, they try to figure out some reason they don't owe them. And frankly, the courts haven't been amused with those excuses of why they shouldn't pay assessments when they're in an association. However, the twist in Swan Creek was the association, as contemplated in the original CC&Rs, had failed at some point to file their annual return. Therefore, their corporate status lapsed. They didn't try to reinstate timely. Back then, at the time of that case, they only had 1 year to reinstate, but they didn't timely reinstate. One of the owners of this, a lot of owners in the subdivision decided, though, that, hey, we need an association. We need to collect assessments. We've got maintenance to take care of. Call the meeting of the members. some of the members showed up, whether a majority or not, who knows, but they showed up, they take a vote, yeah, we need to reincorporate. So they formed a new corporation, a substitute corporation, if you will, to take the place of the original corporation. And then they started levying assessments under the name of that new corporation. The Warrens, however, were not amused, and they said, look, I never agreed to be part of that newly formed corporation, that substitute corporation. The only way someone can be a member of a corporation is if they choose to be, and I didn't ever choose to be. Yes, I was part of the original association, but not this new one. And the Utah Supreme Court, instead of looking at principles of corporation du jour or whatever, they just exercise their equitable powers. Again, I'll sort of quote a little bit from this so you can see the context. It says, the court disagreed about whether the majority of the members took a vote, and it created a material issue of fact, whether a majority vote was taken or not. And they said, we don't care. We don't think that those facts are material. Therefore, using our equitable powers, we declare the HOA to be a valid association authorized to impose assessments pursuant to the terms of the declaration. Our equitable powers extend to situations where the invocation is necessary to correct mistakes and oversights and to protect the public interest. In the spirit of this principle, we call on our equitable powers to affirm the association's authority to levy assessments here. And because the property owners generally treated that substitute corporation as the association, once again, there was a ratification of the act to levy the assessment, but not a ratification of the covenants as a whole. So I think that some of us in the HOA community wanted to jump too far and too fast with the high country estates cases and say, covenants can be ratified. Look, the high country cases showed that that is possible. What the high country cases really show is that the court has chosen not yet to address that issue. They chose to address a more narrow issue and say, oh no, the only thing before us is the question of assessments, and that's all we are addressing. And so they didn't listen to the landowners' arguments about why the association would have failed to have ratified the covenants themselves. So, so that's the creation of covenants, expressly by the developer declaring a government entity may be able to impose an association upon an area for equitable and necessary reasons. Covenants can be implied, although it's a very tough standard. I think it's still possible in Utah that a court may ratify covenants in whole or in part, though they haven't yet dealt with that. My guess is, if properly briefed, the courts would ultimately not ratify covenants, but would go back to the covenant by implication doctrine and apply those standards to determine whether covenants apply, even though maybe improperly done or even not recorded against land, but are part of a common scheme of development. Seeing I have a little time, I also wanted to address what I see is an emerging issue, a concerning emerging issue with covenants and their amendment. That concerning issue was first sort of brought to my attention, well, in some litigation I've been in Park City, but the Arizona Supreme Court has taken a very paternalistic approach to amendments of covenants. That case where the Arizona Supreme Court took that approach is Kalway, that's Kalway. versus Calabria Ranch HOA. That's a 2022 case. I'm not going to talk about the entirety of the case, but I'll focus in on a certain provision, the livestock provision. And this was I think there were 7 properties in this association. And 6 of the 7 property owners decided to amend their covenants and in part put further restrictions on the livestock allowed inside the subdivision. And this was the restriction that it said the original covenants dealt with livestock. And that was defined this way. The declaration defined livestock as not limited to horses and cattle, but livestock not limited to the horses and cattle. 6 of the 7 landowners then agreed to amend the covenants to include chickens. And chickens were then prohibited as a type of livestock that could be kept on the properties. One owner said, look, when I bought under the CCNRs, the term livestock didn't include the term chickens. And so we don't think that that covenant should apply to us because we couldn't have foreseen that when we bought in that the definition of livestock, whatever that definition may be, could be expanded to include and prohibit chickens. And this is what the Arizona Supreme Court said. We need not determine exactly which animals are considered livestock in the original declaration. Whatever the definition under the original declaration, livestock was expressly not limited to horses and cattle. And reasonable landowners may have believed chickens were not livestock under the original declaration, and therefore not subject to the number limitation. An amendment that redefines livestock is so drastic is sorry, let me read it. An amendment that redefines livestock so drastically so that other livestock are prohibited by the amendment is not reasonable or foreseeable. The change unreasonably alters the nature of the original CCNRs and was not portended by them. So one owner says, hey, I didn't think that chickens could be included. And the Supreme Court said landowners may have. I mean, this subjective may have believed chickens were not livestock. And on that may have belief, the court said, sorry, the CCNRs weren't clear enough that chickens could be included in the definition of livestock. And then the Supreme Court went on to blue pencil the amendments and strike out what they thought was the offending language from the covenant. A very paternalistic approach. In Utah, by contrast, and that would be the Swenson versus Erickson case, and I got it on my desk here somewhere. But in that case, the covenants provided that they could be amended in whole or in part. And the members at one point voted to terminate the covenants. And Mr. Swenson didn't like that. He liked the restrictions. And so he brought suit. Actually, there was at least 3 different Swenson versus Erickson cases. They brought suit saying, you can't terminate the covenants. You can amend them in whole or in part. And the Court of Appeals said, and the Supreme Court didn't overturn this, said, well, the ability to amend in whole, we think, means the ability to even terminate. So in that case, a general amendment clause allowed the complete termination of the covenants. Utah is more in line with states like Texas, where a general amendment clause is sufficient to amend any portion of the covenants, and it applies to everybody as long as you get the requisite vote. But in Arizona, that's not the case. I'm a part of the Community Association Institute, and we have currently in a new case in Arizona authorized and submitted an amicus curiae brief trying to ask the Arizona Supreme Court to reconsider its decision, in part because the Arizona Supreme Court says that you must look at the covenants at the time each individual owner purchased and determine the covenants in place at that time, whether as to them, the covenant, it was really foreseeable from within the documents that such an amendment could be made. And you can imagine the challenge that places upon associations and HOA legal practitioners is, okay, properties are bought and sold all the time. Are we going to have some Swiss cheese effect on what covenants apply to who, depending on when they purchased and what version of amendments was in place at that time? It's kind of a mess. However, the restatement of property third, the servitudes, in section 6.10 supports that kind of analysis. We just got through with a case in Park City. Well, we're not entirely through with it. It might go up on appeal. But our office and then Jeremy Reitzel of Bennett, Tuller, and Deere, he and his team helped the litigation portion of that case. But in that case, the judge decided, correctly so, that Utah has not yet adopted this portion of the restatement. And when I say this portion, section 6.10 of the restatement. I'm going to read that to you because I think, again, it's concerning. The section 6.10 of the restatement has not been adopted by Utah, and so the district court refused, despite the plaintiff's request, to apply section 6.10 in that case. But this is the concerning part of section 6.10. It says amendments that do not apply uniformly to similar lots or units, and amendments that would otherwise violate the community's duties to its members under section 6.13. 6.13 says the association has an obligation to act reasonably towards its members. So the way the courts have applied this, or the way the comments to 6.10 applies this is, your amendments must be reasonable. And if they're not reasonable, then they do not apply to those people who do not vote in favor of those amendments. And there's only two exceptions to that reasonableness requirement. And this is comment F of the restatement. It says, there are two exceptions to the requirement that approval of the members adversely affected is required. If the declaration fairly apprises purchasers that such amendments may be made, and if the circumstances are such that a judicial modification could be made, which is rare, okay? So really the exception is, did the CC&Rs fairly apprise these people complaining that it adversely affects them, that it apprised them that such a change could be made? In Arizona, restrictions on livestock, it was determined by that Supreme Court that that was not sufficient to apprise the owners, the purchasers, that a restriction on chickens could then also be adopted. My recommended takeaway from all of that is, if you want in your covenants, the covenants of the associations you deal with, for a general amendment clause to allow for amendments of any and all portions of the CC&Rs, that you might as well state it that way now, rather than having a court try to interpret it in the absence of that language. In other words, you may want to include in your covenants a clear statement that every word, phrase, term, covenant, servitude, if this declaration can be amended by the 2/3 vote, or wherever the voting process and procedure is under those CC&Rs, to avoid this potential problem. When I say potential, Utah hasn't yet adopted Section 6.10 of the restatement. They haven't followed yet the Arizona's lead on being paternalistic with CC&R amendments. But if you want to avoid the risk of that happening, then by contract, as Jeremy was pointing out earlier, by contract, have the covenants provide that the general amendment power applies to everything in there, and anything in there is open to amendment under those general amendment provisions. So for me, that's sort of the general principles with respect to covenants. They can be expressed, they can be imposed by a government. They can be, under limited circumstances, implied under a burden of proof, which I think is somewhere around the clear and convincing standard. Maybe covenants in Utah would be subject to a doctrine of ratification, but that's still open. And as I said earlier, I mean, if I was on the bench, which I'm obviously not, people perhaps a lot smarter than me are there, but if I was on the bench, I wouldn't likely consider covenants as a whole being ratified under a doctrine of ratification. I would rather look at it under the covenants by implication standard and apply those principles. But we'll still have to wait to see what Utah does. And with respect to amendments of those covenants, it's not as well settled as you might think, that simply because the contract allows for amendment, that amendment is going to apply to everybody. That question may not be so simple. And lastly, according to the question in line with the question I first asked, not everything in CC&Rs are covenants. Almost everything, but not everything. And with that, I probably wrapped up 2 or 3 minutes early, but that's it. And I'll turn the time back over to Jeremy to introduce Scott.
Thanks so much, Bruce. Gosh, those crazy Arizona people. With that
Yeah,
one,
don't move to Arizona. Yeah.
with